Good morning, everyone. It's a pleasure to welcome everyone here this morning to the 11th meeting of the Public Utility Commission for calendar year 2014, and ask that you join us this morning in the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The first matter on this morning's agenda is the approval of the minutes from the May 22nd meeting. It's a pleasure to recognize Commissioner Brown as the editor of the minutes. Commissioner Brown.
Thank you, Mr. Chairman. I have reviewed the minutes of May 22nd of this year's public meeting, and I move that they be approved as submitted.
Second.
Any discussion? Any objections? Hearing none, the minutes are approved as submitted. It's a pleasure to welcome to the podium to commence with public meeting Ms. Cheryl Walker-Davis. Good morning, Cheryl.
Good morning,
Good morning.
May it please this honorable commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Bureau of Audits on page 1 of the public meeting agenda. It is recommended that the commission adopt the two recommendations appearing there to release the audit reports with regard to the Citizens Electric Company and Wellsboro Electric Company generation supply service rates.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Bureau of Consumer Services, on page 2 of the public meeting agenda, it is recommended that the commission adopt the recommendation to adopt the proposed tentative order involving PPL Electric Utilities Corporation's Universal Service and Energy Conservation Plan for the years 2014 to 2016.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Office of Competitive Market Oversight, on page 3 of the public meeting agenda, we recommend the adoption of the recommendation with regard to the eligible customer list.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
And on behalf of the Office of Special Assistance, commencing on page 4, we recommend the adoption of the first item pertaining to the application of Scranton Transportation, LLC.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
It is recommended that the commission adopt the recommendation with regard to the Bureau of Investigation and Enforcement versus Rescom Energy, LLC, noting the statement of Commissioner Cawley.
So moved.
Second.
I'd like to recognize Commissioner Cawley for purposes of a statement. Commissioner Cawley.
Thank you, Chairman. We have before us the informal investigations of Rescom Energy, LLC, instituted in September of 2012 and July of 2013. These investigations pertain to allegations of slamming, which, as we all know, means unauthorized changing of a customer's supply service. And the investigations also concern allegations related to unauthorized electric generation supplier marketing practices by the company within Pennsylvania. The parties submitted a settlement agreement and statements in support of the settlement agreement. We issued an order directing the parties to file supplemental statements in support, which were filed in April of this year. The slamming allegations stemmed from 3 customers who were physically switched and were customers of Rescom for a period before being returned to their prior electric generation supplier. While the record clearly describes the activities alleged and how many customers were affected, including other customers who were slammed or allegedly slammed by Rescom, but were not actually switched because they stopped the process before being switched to Rescom. The record does not provide any information on the treatment of the 3 customers who were switched and were with Rescom for a period of time. Were these customers financially harmed by the alleged slamming? And if so, were they compensated? Since we are issuing a tentative order, I ask that the parties elaborate on the treatment of the 3 customers and answer the questions that I have posed. Thank you.
Thank you, Commissioner Cawley. Any further discussion or any objections? Hearing none, the motion passes unanimously, noting Commissioner Cawley's statement.
Continuing with matters on page 5 of the public meeting agenda, it is recommended that the commission adopt the staff recommendation in the application proceeding involving La Mexicana Express Service LLC.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
We recommend the adoption of the staff recommendation in the complaint proceeding involving Mohammed Mansoureh versus Pico Energy Company, noting your statement, Mr. Chairman, as well as the joint statement of Commissioners Cawley and Brown.
So moved.
Second.
I'd like to recognize Commissioner Cawley for purposes of the joint statement. Commissioner Cawley.
Again, thank you, Chairman. This statement is a dissenting statement on behalf of Commissioner Brown and myself. We have before us a recommendation that Mr. Mansoureh's his exceptions to an initial decision be rejected and the initial decision of the administrative law judge be adopted. Mr. Mansoureh alleged that he overpaid PICO and that his bills were too high. At the initial hearing, the complainant, representing himself, asked for an interpreter. The administrative law judge very properly continued the matter so that an interpreter could be provided. At the subsequent hearing, the interpreter was unexpectedly unavailable, and the complainant requested another continuance. The ALJ presented the complainant with two options: either proceed in English at the present hearing, or have his complaint dismissed without prejudice. So either proceed, or I'm going to dismiss your complaint and you can refile it at a later date. We regard that as a Hobson's choice. A Hobson's choice is a take it or leave it proposition where two options are offered when you really only have one choice. And in this instance, he took that choice, and he really didn't want to have to refile his complaint and come back later, so he made the best of it and decided that he would proceed without an interpreter. The complaint, when a complaint a complainant asks for an interpreter should be provided. And in this instance, the ALJ should have once again granted the continuance, and this would, we believe, have safeguarded the complainant's rights, his due process rights in a better fashion. And in fact, the Commonwealth Court has specifically said that the constitutionally protected rights afforded by due process, which apply to administrative proceedings, include the right to be heard, which in certain circumstances include the right to have assistance from an interpreter during the proceedings itself. Now, I know the chairman has his own statement, and Commissioner Brown and I don't want to make a big deal of this, but really what it comes down to is whether an adequate hearing was given to this individual, and whether he had a fair opportunity to be heard. I think our differences of opinion really come down to whether, as out of an abundance of caution, another hearing should have been afforded with an interpreter. That's really where the nub of the case comes down to us. We would have given him another hearing with an interpreter. Thank you, Chair.
Thank you, Commissioner Cawley, as well as Commissioner Brown, for the joint statement. Fundamentally, if you want to look at it from a football analogy, it's the difference between being a Steelers fan and an Eagles fan here this morning.
Careful there, Mr. Chairman.
Yes. Respectfully, after deliberation and consideration, I agree with the order. It upholds the ALJ's decision to allow and have discretion to proceed without an interpreter. And judging from the credibility of the witness is squarely within the realm of the ALJ as the fact finder. As such, I think we believe, the majority believes here today, it's appropriate to defer to the ALJ's factual determination on this issue. While in many cases the assistance of an interpreter is very important to the safeguards, and Commissioner Cawley alluded to these due process rights in this case, the interpreter's unavailability was harmless error that did not prejudice the complaint's ability to litigate the case. Let me simply add that prior to the rescheduled hearing, the commission attempted, obviously, to find an interpreter for this complainant. And when that attempt was unsuccessful, the commission obtained the services of Pro Translating, Inc. to provide an interpreter. And again, for the record, on August 7th of 2013, the commission's scheduling unit confirmed the availability of the interpreter and provided the ALJ with instructions for contacting the individual interpreter. Now, granted, on the day of the hearing, the ALJ contacted Pro Translating, but was informed that the interpreter was no longer available. No other interpreter could be made available. The complainant agreed to move forward with the case. So I simply want to note that here this morning. And again, this is just a gentleman's disagreement in how we interpret this case, and it should be no indictment on the work of this ALJ in handling this case. It's simply, again, we defer to the ALJ as the fact finder in this particular case here this morning, and we uphold the decision that was made. Any further discussion?
Mr. Chairman, I'd like to associate myself with your statement this morning.
Thank you, Vice Chairman. Any further discussion? We'll note here this morning that the approval of the motion is 3-2, noting the objections of Commissioners Brown and Cawley.
Continuing with the presentation of agenda items and matters on behalf of the Office of Special Assistance, it is recommended in omnibus fashion that the Commission adopt all of the recommendations appearing on pages 6, 7, 8, through and including the first two items on page 9, that being Consolidated Communications of Pennsylvania LLC and AT&T Mobility LLC.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
We recommend the adoption of the staff recommendation with regard to the interconnection proceeding involving the Commonwealth Telephone Company LLC, DBA Frontier Communications, and North Penn Long Distance Corporation, noting the statement of Commissioner Brown.
So moved.
Second.
I'd like to recognize Commissioner Brown for purposes of her statement. Commissioner Brown.
Consistent with Section 1102 of the Commonwealth Ethics Act, I will be recusing myself from this matter because my brother is employed by Frontier Communications.
So noted. Are there any objections? Hearing none, the motion passes 4-0, noting the recusal statement of Commissioner Brown.
Turning now to matters on behalf of the Bureau of Technical Utility Services, in omnibus fashion, we recommend the adoption of all of the recommendations appearing on pages 10, 11, 12, except the last item pertaining to Energy Cooperative Association of Pennsylvania, which has been withdrawn by the Bureau. The omnibus continues with the recommendations appearing on page 13 through and including the third recommendation pertaining to the application of Unique Energy, Inc.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
We recommend the adoption of the staff recommendation with regard to the application of Gamma Ventures LLC, noting your joint statement, Mr. Chairman, with Vice Chairman Coleman.
So moved.
Second.
I'd like to enter into the record here this morning the joint statement with the Vice Chairman. This morning for consideration is Gamma Ventures LLC, whose issue is requesting that we issue a certificate of public convenience as a competitive access provider. The Vice Chairman and I want to thank our staff, Technical Utility Services, and Law Bureau for providing a forum in which Gamma could explain its business model. Gamma intends to gather and distribute mobile wireless traffic through a distributed antenna system that requires placement of infrastructure on utility poles, street lamps, or municipal right-of-ways. There are several issues presented here, the most significant of which is whether Gamma is offering wireless service that could expressly exclude it from our jurisdiction under Section 102. Gamma argues here this morning, however, that the Commission has previously granted CPCNs to carriers seeking cap authority that are also engaged in operating a DAS to transport traffic. Therefore, we don't oppose granting Gamma cap authority in Pennsylvania at this time. However, I just wanted to be known, we had a very similar case in Bucks County, Pennsylvania, that got a little bit of statewide attention, and the issue involved the owner-operator going into the community, not working cooperatively with the local municipal officials. In fact, installing this equipment, going through neighborhoods, and really not doing the proper outreach, which caused a lot of, I'll call it, political backlash from local communities. And all we're asking, and again, commend Gamma. They came in, met with us, took a very proactive approach to agree to stay away from the use of eminent domain, work with local municipalities. We think that's a good outcome here this morning. And Gamma has stated that the principal reason for its application is that it would not be permitted to attach to utility poles by our regulated utility companies. Access to utility poles is an existing right of all telecommunications carrier and does not require a certificate from this commission, which we agree with here this morning. Is there any further discussion? Commissioner Cawley, you have a verbal statement?
Yes, I do. I want to thank you in your joint statement, you and the Vice Chairman, for citing my case in 1999. I represented Vanguard Telecom.
Honored to do so.
You didn't know you were doing it, admit it.
It's like serendipity.
No, so I'm familiar with competitive access providers, and you correctly point out, and a part of your statement you did not read, that the Telecommunications Act of 1996, the federal TA 96, provides that access to utility poles is an existing right of all, quote, telecommunications carriers, and this is clearly a telecommunications carrier. I would also respectfully point out that Gamma Ventures will be providing dedicated landline wholesale transport services for the traffic of wireless carriers as a CAP, or competitive access provider, in competition with at least 5 other CAPs that this commission has already certified and that are already operating within the Commonwealth. Similar wholesale transport or backhaul services are also provided through the special access services of numerous other providers, including incumbent local exchange carrier telephone companies that operate under our jurisdiction. So I think what we're doing today here is merely confirming our long history of encouraging competitive entry of telecommunications service providers consistent with Pennsylvania and federal law, where we have implemented and enforced the Federal Telecom Act. And what we're doing today here is reaffirming those prior decisions and properly allowing Gamma to provide this competitive access provider service. Thank you, Chairman.
Thank you, Commissioner Cawley. Any further discussion on this case? Any objections? Hearing none, the motion passes unanimously. Noting our joint statement with the Vice Chairman and myself, along with Commissioner Cawley's verbal statement.
Continuing with matters on behalf of the Bureau of Technical Utility Services, it is recommended in omnibus fashion that the Commission adopt all recommendations appearing on pages 14, 15, and 16 through and including the petition of the York Water Company.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Law Bureau, it is recommended that the Commission adopt all matters commencing with the recommendation in the rulemaking proceeding involving household goods carriers at the top of page 17, continuing with the remaining item on page 17, as well as both items appearing on page 18 through and including the order pertaining to the petition of Lackawaxen Telephone Company with regard to its PSI SPI filing.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
And on behalf of the Office of Administrative Law Judge, we recommend the adoption of all of the judge's recommendations appearing on page 19 through and including the recommendation with regard to the NFG tariff supplement involving the joint stipulation of settlement.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On page 20 of the public meeting agenda, we recommend the adoption of ALJ Salapa's initial decision in the complaint proceeding involving Andre Furman and Elsie Gallagher Furman versus Philadelphia Gas Works, noting the joint statement of Commissioners Whitmer and Brown.
So moved.
Second.
I'd like to recognize Commissioner Whitmer for purposes of the joint statement. Commissioner Whitmer.
Thank you, Mr. Chairman. I would like our joint statement entered into the record as if I'd read it in its entirety. Before the Commission is the initial decision disposing of the complaint of Andre Furman and Elsie Gallagher Furman against Philadelphia Gas Works. The complainants allege that PGW placed a lien against their property in the amount of over $11,000 for arrearages accrued about 10 years ago by a previous owner. Commissioner Brown and I wish at the outset to state for the record that we concur with the decision of ALJ Salapa in this case. It is well settled that the filing of a lien, as well as any challenges to the validity and enforcement of a lien, are solely within the jurisdiction of the Court of Common Pleas, and this Commission has no jurisdiction over the subject matter. Having said that, however, we are troubled by how this case played out. According to the complainants, PGW terminated natural gas service to this property in 2002 based on the arrearage from a previous owner. The complainants purchased the property in August of 2003, but did not establish gas service until early 2004. Then, in 2009, 5 years later, and 7 years after the termination, PGW finally applied the lien to the property. The complainants allege they did not learn of this lien until 2014. We hope PGW can follow the math. Assuming these alleged facts and the timing are accurate, we are very concerned that PGW seemingly did not work diligently to keep individual customers informed of arrearages, did not keep individual arrearages at a more manageable level, and did not aggressively pursue other collection options before resorting to filing a lien. We wish to remind PGW of two things. First, we strongly encourage PGW to continue to evaluate how and when it chooses to apply a lien to ensure that we do not see more cases similar to this one, where the property owners would have difficulty anticipating that the property they were buying in 2003 could be subject to a lien 6 years before the lien was applied, and a lien for a debt at least partially incurred by the prior owner. And second, the company must continue to work to manage customer arrearages, including pursuing all collection options before filing a lien on a particular property. Thank you, Mr. Chairman.
Thank you, Commissioner Whitmer and Commissioner Brown, for your joint statement. Is there any further discussion regarding this case? Any objections? Hearing none, the motion passes unanimously.
Mr. Chairman and Commissioners, that concludes the presentation of regular agenda items. Turning now to the carrying agenda. And on behalf of the Bureau of Administration, we recommend that the Commission adopt the assessment upon local exchange telecommunications companies for the Broadband Outreach and Aggregation Fund for fiscal year 2014 through June 30th of 2015.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Bureau of Technical Utility Services, we recommend the staff recommendation regarding the tariff supplement of Duquesne Light Company to eliminate the distribution loss charge involving certain transmission voltage customers.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
And that does conclude the presentation of agenda items.
Before we adjourn here this morning, I want to recognize Commissioner Whitmer. We received a notice this past week from Representative Donna Oberlander regarding P8 Line Worker Appreciation Day. And I know many of us have been out in the field. In fact, I have pictures of the vice chairman working with the line crew. Actually, you were up on the poles, I think. And we think about how blessed we are in Pennsylvania when events like Hurricane Sandy and other weather-related events. Notice I didn't use the word solar vortex. Okay, everybody can laugh. It's Thursday. But I want to recognize Commissioner Whitmer because this is about a recognition entitled P8 Line Worker Appreciation. And I think unanimously here, we have a great deal of appreciation for the work that the men and women of our utilities and mutual assistance crews do during weather events like Hurricane Sandy and numerous other events that have hit this commission. So with that, Commissioner Whitmer, I want to recognize you here this morning.
Thank you, Mr. Chairman. There isn't, my statement will be very brief. I just wanted to congratulate and thank Representative Oberlander for recognizing June 22nd, 2014 as Line Worker Appreciation Day in Pennsylvania. As if you read her resolution, House Resolution 566, you'll get some statistics about line workers and what they do. Obviously, as the chairman noted, line workers, men and women, go out into the field every day in various types of weather, much of it when it comes to the public's attention in very hazardous conditions. And wanted to point out that through the hard work and dedication of our women and men that are out there on the front lines, with the various storms that we've had going back 2011 to Hurricane Irene, all the way through the ice storm of this year, there was not one fatality or serious injury that was sustained by the women and men that are out there restoring our power. So with that, I would like to, on behalf of my colleagues, say thank you to the hard work that the women and men do for us in bringing power back, even just on a blue sky day when a pool might be struck by a car. So again, thank you to Representative Oberlander, but more importantly to the men and women who are out there every day. Thank you.
Thank you, Commissioner Whitmer, and we all associate ourselves with that statement. The last item I want to report here, we will reconvene at 1:30 here this afternoon for our annual employee recognition program. And with that, we're adjourned.